Thank you all again for joining today's webinar brought to you by the Tribal Law and Policy Institute. Again, today's webinar is titled Strengthening Tribal Sovereignty, Enforcing Protection Orders under VAWA, and will be presented by Kelly Stoner, Victim Advocacy Legal Specialist with Tribal Law and Policy Institute. I will now turn it over to Kelly to introduce herself and to get us started.
Thank you, Chantel. Hello, everybody, and welcome. Happy to have you here at the webinar. I'm Kelly Stoner. Just a little about myself. I have worked with TLPI for 13 years. I'm a victim advocacy legal specialist there. I also participate in providing technical assistance to the Intertribal Working Group, or the ITWIG, which is comprised of tribes across the nation that are working towards or have already implemented VAWA 2022, Special Tribal Criminal Jurisdiction over non-Indians committing certain covered crimes in Indian country. I'll touch on that just a little bit later. I'm currently an associate justice on the MHA Nation Supreme Court. I'm a former judge for the Seminole Nation of Oklahoma for 8 years on the bench there, and I saw Seminole Nation has a representative here, so super welcome. I've spent over 22 years as a law professor teaching American Indian law, tribal law, domestic violence, and the lawyer, and the Indian Child Welfare Act. So hopefully I'm going to bring a little expertise today to the topic, but a couple of things I wanted to start us off on here. If at any time you have questions, I'm going to, unless we get overwhelmed with questions, going to ask you to put those in the chat or the Q&A function. Please ask questions if you have them. I'm here to try and answer those questions. And I'm going to ask you a question here. I should tell you also, I'm coming from the beautiful state of Utah. I have relocated to Heber City, Utah, and I saw someone here from the Utah Coalition, I think, so welcome. My first question to you all, just so I can kind of tailor what I'm saying to your interest, could you chat yes if you are experiencing difficulties having tribal protection orders enforced outside of Indian country, or no if you are not? Or I guess you could put, I don't know, if you haven't tried to do that. Okay, I want to take a moment just to let everybody answer that so I can see what I'm getting. I know Alaska seems to be experiencing some difficulties in this regard. I'm keeping my eye on that. Okay. Okay. Yeah, and it seems like some are saying maybe one county is more difficult than the other. Okay. Okay. Okay, too many yeses. I was just saying to my TA team here before we got started, isn't it sad? We have a federal law that requires this, and it's the majority of protection order enforcement issues outside of the issuing jurisdiction. So this, in our case, would be outside of the tribal jurisdiction. We are still struggling. And I also wanted to let you know, in the past 6 months, I've done some trainings for various state judges. And it's interesting to me, one of these trainings, they did a pre-test and a post-test, and the answers the judges gave about the federal mandate to enforce, I'm going to say, qualified protection orders, they seem to say without a doubt they should be enforced as they're written. So we're just going to keep marching forward. We're just going to keep training both state judges and tribal folks about this issue and what the protection order has to have in it in order to activate the federal requirement, the mandate to enforce the protection orders as written. So let's go to the next slide. Here are the learning objectives today. At the end of my presentation, you will, I know you will, understand the importance of enforcement of tribal protection orders, understand the concept of the VAWA full faith and credit for protection orders. You will be familiar with the federal definition of what qualifies under the term protection order, and you'll be able to list the protection order language necessary to activate the full faith and credit mandate. I also tossed in at the end some special tribal criminal jurisdiction information for you all, but I'll go over it briefly, but I want to really focus on that covered crime of violation of a protection order, where a non-Indian comes into Indian country and there's a valid protection order there that meets the full faith and credit requirements and violates a provision of that protection order, and the tribe wants to prosecute. So we're going to talk about that. So let's move on to the next slide. Let's get right into it. And for those of you who may be new to the topic, and maybe you're new even to working with victims of domestic violence, sexual violence, why is this? What is full faith and credit? What is cross-jurisdictional enforcement? And it's when, in our instance, for purposes of today, we get a tribal court protection order issued, and then the holder of the protection order, the protected party, goes outside of Indian country, and that protection order is violated, and it needs civil enforcement. It may need criminal enforcement. And that is so important. If you think about these victims who are getting their protection orders in Indian country, they're probably not going to stay in Indian country 24/7, 7 days a week. They're going outside to get food. They're going outside to shop. They're going outside to visit. They may take a vacation. And so what I'm hoping is to get everyone on the same page about what the tribal order protection order must contain. So when that victim goes out, there's a chance, I hope it's a good chance, that the outside jurisdiction, if it's violated, will civilly enforce it or criminally enforce it. So let's go to the next slide. And cross-jurisdictional enforcement is important because, for all these reasons, I sort of got ahead of myself telling you that victims travel. They have lives that require them to get outside of Indian country. And I think the bottom two bullet points are the ones I want to stress here, although they're all important. When that perpetrator, the abuser, the offender, knows that this tribal protection order will be enforced outside of Indian country, it sends a message to that perpetrator. Don't think you're going to go outside and violate, because there will be consequences there. And the last, and it's certainly not last, is when that happens, when we get outside jurisdictions enforcing tribal protection orders as they are written, it is a recognition of tribal sovereignty. Yes, the tribes have the authority to issue this order. And yes, there is a federal mandate that if the order contains certain language, we must enforce it as it is written. Next slide. Let's move into full faith and credit. And again, that's where those outside jurisdictions are recognizing the tribal protection order and they're enforcing it as the tribal judge wrote it. Let's go to the next slide. And this is exactly what I've been telling you. You'll have this on a slide deck in case you forget what full faith and credit means. And the last bullet point on this slide is super important, and it would be super important to me as a victim. It doesn't matter if the tribal protection order, I'll give you an example. A tribal protection order provides custody provisions, saying one party's going to have custody and they'll put some visitation or not in the tribal protection order. And in Oklahoma, where I'm from, Oklahoma does not allow you to address custody orders in a protection order. You can put the child on the protection order, but you have to meet the burden of proof there and they become a protected party. Do you see the difference? Because we all know domestic violence cases are about power and control. And I can almost promise you, with all my years of experience working on these cases, the children will be used as a method of maintaining power and control. So let's say the tribal court, the Seminole Nation in Oklahoma, for instance, I'll just use it as an example, issues a tribal protection order and it has custody provisions in it. That victim says, well, I'm going to go visit my auntie, and she lives 2 hours away outside of Indian country. She's taking her protection order, and the perpetrator shows up and he wants to take the kids. And the police are called, and they look at the protection order and say, oh, we don't allow custody provisions in our protection orders. The federal law says the order is to be enforced as it's written. It doesn't have exceptions. It says that the order has these particular phrases in it, these words, these statements. It is to be enforced as written. Now, I know in real life that's not what always happens. I know we're struggling because I saw all the yeses in there. And there are certain states that this is a real problem in, and we've done training there, and we've got memos from their US attorneys or their attorney generals, and it says you must enforce it as it's written. Um, and so I just want to tell you the language is there. I know up in Alaska there are some struggles with the full faith and credit provisions that deal with how close a perpetrator can come to a victim and those sorts of things. We're going to give you some tips later on some of this and a great resource for it. But overall, that's what the full faith and credit statute says. It is federal law. It should supersede state law under the federal supremacy clause, but we're still having some struggles with it in practice. Next slide. Here's what the federal law says. I don't want to bore you with it, so I've highlighted the really, really important pieces here. And this says any protection order, and I'm going to tell you what the federal definition of protection order is in a few minutes, that's consistent with subsection B shall be afforded full faith and credit by the court of another state, another tribe, or a U.S. territory. And there's that language again. Enforced by the enforcing court where the violation has occurred, and law enforcement personnel by that state. And if it's a tribe, it would be tribal law enforcement, as if it were that state's own order. If you have any questions, if I haven't explained it or you're just unsure, go ahead and start putting things in the chat for me so that I could explain it a little bit further. I work with it all the time and it becomes second nature to me. And if I haven't explained it fully, please let me know. So we've got this down. The victim gets her order in tribal court. It's got to have certain pieces in it. I'm going to go over those. When that victim takes it outside of Indian country, this is the federal law. If they're in Oklahoma, Oklahoma will enforce it as it was an Oklahoma order. Okay, next slide. This is the subsection B I just mentioned, and this is where we get into the nitty gritty of what the protection order must have in it. And normally I don't advise or even suggest to tribes to write language exactly as it is in the statute. But this is an exception to that for me because law enforcement and other jurisdictions are trained to be looking for this exact language. So a protection order that's issued by a state, a tribe, or a territorial court is consistent. It's activating this full faith and credit if the issuing court, in our case, it's the tribe, has jurisdiction over the parties before it and has authority to issue protection orders. And where do we look for that? We look for the tribal code. And it should say, and I'm really going to encourage you all to get your tribal codes out. See where it says it's creating the courts. It may have a civil court and a criminal court, and there'll be a statute number there. And it may say something like, the civil court shall hear all civil matters. That's what I'm looking for, because a protection order, like we're talking about right now, is a civil order. So, and then when we talk about the no contact order that your tribal prosecutors may be issuing, those orders can qualify for full faith and credit if they contain this language as well, but that would be a criminal case. Make sense? I can't see you, but I'm hoping you're shaking your head. Yes. All right. That's the first thing we need. The second thing is the protection order language in the order itself must say that the respondent, the defendant, the perpetrator, the opposing party, whatever name you want to use, was given reasonable notice and an opportunity to be heard. And I think that's super important. Usually our court clerks are the ones who are sending out the notices of hearing, sending out a copy of the petition for protection order and the affidavit that goes with it, and telling them you must show up within a certain number of days, which you should find in your tribal code. And so making sure you've got that tribal code out and you're cross-referencing it, because I'm gonna give you a tip later that's going to require you to use the tribal code numbers. Okay, if it's an ex parte protection order, these are the kinds of orders that we sometimes call emergency orders. Things are so bad, it's so dangerous. I'm going to take the client in front of the judge, and the judge is only going to hear one side of the story. And if the judge finds there's imminent danger, danger of imminent harm, the judge will order this emergency ex parte order. And then we look to the tribal code to see how many days before we have to have that full hearing. And that should be in the order as well. Because even though that defendant, the abuser, has not received notice of what's going on yet, and there's a protection order, as long as we say we're going to have a hearing within whatever the tribal code requires us to, that order is enforceable. It's enforceable as it's written. So I just want to make sure you all know that. And the reason, this is sometimes called due process. The reason for that is it's fairness. The defendant right now with this ex parte order hasn't even seen the protection order. How would he know if he violated it yet? It's still enforceable according to federal law if we're saying we will give reasonable notice and opportunity to be heard. Okay, it's very important for you all to become familiar with what your tribal code says, because every code is different about how many days from that initial emergency order we have to have a hearing. And sometimes we can't get service. That's okay, because the codes usually say the judge can continue it for good cause. And so we'll just keep pushing forward with it until we get notice on that defendant. Next slide. So that's it, folks. That's what your orders are going to have to say. I broke it down again here a different way. The order needs to say, I usually break this first bullet point down when I'm drafting orders into two pieces. I will say this tribal court has jurisdiction over this subject matter according to Tribal Code 123. This court has jurisdiction over the parties. And we don't worry so much about the applicant. We worry about that defendant. Do we have civil jurisdiction over that defendant to issue protection? Or what if it's a non-member? What if it's a non-Indian? I'm going to give you a federal statute that says, yes, tribal courts have full civil authority to issue protection orders in matters involving all persons. And that's federal law reaffirming tribal inherent authority. Again, jurisdiction of the parties, jurisdiction of the subject matter, reasonable notice, and opportunity to be heard. Now, I've talked about these ex parte or emergency orders already. And just so you can kind of remember this, ex parte, I think it's Latin for only one party. It's not a full hearing, only one side was heard. That's my Oklahoma interpretation of Latin. All right. In the case, and I don't see these as much as you all, as I did when I started out 30 something years ago. We would go in, I would go in with a victim, and we would have a petition for a protection order there. The defendant would be there, and the defendant says, well, if she gets one, I get one. And the judges back in the day would say, okay, well, I'll give you both one. That's not entitled to full faith and credit unless the defendant does a filing, request for protection or filing, and then the court has to make specific findings on the record, put it in the order about why both sides got a protection order. And whatever the tribal code says needs to be demonstrated, a protection order, judge has to say that and say, I heard testimony today and the defendant says these things, the plaintiff says these things, I believe both of them, so I'm going to issue it. And it has to say subject matter jurisdiction of the parties, and reasonable notice opportunity to be heard has been given in order for counter or cross petitions to be entitled to this full faith and credit mandate. I see a question in the chat. Have other courts had issues with terms? No. Oh, I'm glad you brought this up so much. This training I did for judges last week, there was a question about a remedy in the protection order that says no harmful contact. Now, I want you to sit back and think for a minute. If you were a tribal prosecutor, unless the defendant had physical contact with that victim, how would you ever prove that the contact was harmful if there's no physical? I mean, those kinds of remedies drafting in the protection order, to me, they're not going to be enforceable by a prosecutor. I have to prove beyond a reasonable doubt as a prosecutor, tribal prosecutor, that this was indeed a violation, that it was harmful. The victim may say, yes, I was scared. Yes, this, yes, that. I don't think a jury will convict on that. I think it'd be a tough case to win. Whereas if the order's remedy says you can't come within so many feet of the victim, you can't physically contact the victim, you can't contact the victim by any other type of communication, you can't send third parties over to the victim. I need those remedies to be tight. So where you look at them, you say, oh yeah, I'd be able to tell if that had been violated or not. Yes. Thank you, Chantel. Let's go to the next slide. And now let's see, okay, just because you call it a protection order, you might call it a personal protection order, you might call it a restraining order, you might call it a harassment order. There's a whole lot of different names for orders. But this federal definition is probably the most sweeping definition of a protection order that I have ever read. It's clear that Congress wanted a variety of different orders to fit within this definition. So let's take a look at it. Okay. This is broken down. You could actually find the language in this citation up here in the upper right-hand corner of the title. It's an order that's issued by any court, state, or tribe. It can be civil, it can be criminal. And again, we're not looking at what the name is on the order. It doesn't matter what it's called. The definition includes any order. This is what I'm going to be looking for. This needs to be in the order as remedy or remedies. It has to prevent violent or threatening acts. It has to, and you could put physical violence. You can put you could make that more specific. This is the federal law. Or it prevents harassment. Or it prevents sexual violence. Or this order, no matter what it's called, prevents contact or communication with another person. So long as, here's a condition, the civil or criminal order was issued in response to a complaint, a petition, or a motion filed by or behalf of the person seeking protection. So there has to be a filing with the court requesting this type of relief. Also, if you look at the federal law, it will say it also includes child custody, child visitation. It gives you a big list there of what other types of relief can be granted in this big, broad definition of a protection order. Everybody got it? All of these orders, if they contain the language we've already mentioned, those three parts, will activate the federal full faith and credit mandate. Doesn't matter what it's called. So if you have a tribal prosecutor, I have a victim of crime, I'm prosecuting the perpetrator, the offender, and I feel like, or my tribal law requires me to get a protection order, or no, they call them no contact orders usually. I need to get one for my client. I'm supposed to do that. It's mandatory. If I don't stand up on the stand and say, Your Honor, I'm requesting this motion in this criminal case on behalf of the protected party, and then I'm going to do subject matter jurisdiction, jurisdiction over the parties, which court already has because it's a criminal case, and reasonable notice and opportunity to be heard because I'm saying this out loud in court and the defendant's here and he can oppose what I'm saying. And then I'm still requesting this no contact order. That order becomes a protection order and it becomes entitled to full faith and credit no matter where that victim goes. And it can be enforced civilly or criminally outside of the Indian country. Any questions there? Oh, police issue protection orders. Okay, good question. If the police, it doesn't, none of this says, well, it says issued by a court. So we're going to have a court issue it. But the police certainly could go to court and request these protection orders be issued. And all of these things would apply. I would probably be a little concerned just for litigation purposes, unless the police have judicial authority to issue it, and that could be the case. Next slide. Okay, and here's some more of it. You can see it doesn't matter what it's called. And this is basically just adding to the definition of a protection order. Next slide. Here's oh, good. I forgot we put the language of statute in here for you all. So it's right here. You don't have to go look it up, but we've already gone over all of this. But if you take a look at it, these are very broad, and it does include child custody that's contained in a protection order, visitation provisions contained in a protection order. So very broad. Next slide. Okay, some tips for you all in possibly improving enforcement outcomes. Let's get into these. Again, I'm going to say this so many times, you'll all have it memorized by the time we're done here. These first three bullets are the activation language needed in the tribal protection order or whatever kind of order it is that qualifies as a protection order to activate the full faith and credit mandate of the federal law. These are just three short sentences. I would put reasonable notice and opportunity to be heard myself. And this is enough, supposedly, according to what Congress intended, that order can be presented to law enforcement. They're looking for that language. It should be enforced as if it were issued by whatever jurisdiction the law enforcement is in. Remember that ex parte orders, we talked about those earlier. We need reasonable notice and opportunity to be heard. And I think it's best practice to cite to your tribal statute and says the tribal court says within 2 weeks of today's date, but could be continued for good cause. I would want to see the judge put that in there. If it's a cross or counter petition, remember there are special requirements for those orders to activate the federal full faith and credit mandate. Next slide. All right, this is a biggie. Okay, that's all I'm going to talk about, full faith and credit. Enforce it as it's written. You've got the three pieces that you need to have in your tribal court order. And again, my best practice is cite to your tribal code, because outside jurisdictions I know this. I'm sitting on the bench at Seminole, and you'd think Oklahoma would get it right because there's 38, I think, federally recognized tribes here. They just do not, at least the ones I've spoken to on the phone, other judges. I'm a judge, a tribal judge. They're telling me I don't have jurisdiction over something because of some weird notion they got from who knows where. And usually it had to do with non-members or non-Indians. We did have some Supreme Court case law there, but this case, this statute right here, this congressional statute partially overruled a Supreme Court case that said tribes had to run through this special test if they're going to issue orders involving non-members or civil jurisdiction clumps non-members with non-Indians. So you could be a non-Indian and be considered a non-member. Okay. So this did it right here. It says for purposes of this section, now get this, a court of an Indian tribe shall have full civil authority or jurisdiction to issue and enforce protection orders involving any person. So that Supreme Court case called Montana that we'll go over with real briefly, that's partially overruled by this congressional statute, including the authority to enforce orders through civil contempt. Now, this is civil authority to exclude violators from Indian land and to use other appropriate mechanisms in matters arising in Indian country. Now, let me stop there. So what we have here is this statute, full civil tribal authority to issue protection orders involving any person for matters arising in Indian country. So we need something happening in Indian country. I don't know what your tribal statutes would say. Is it fear? Is it threats? Is it stalking? Is it harassment? Whatever that tribal code says, you can get a protection order for this. If some of it, even a tiny piece of it, arose in Indian country, tribes have this full civil authority. And it's been my experience rarely to not have anything happen in Indian country. Even if the perpetrator doesn't reside in Indian country, he will call her and she's taking that call in Indian country. Or he will call her at work and she works in Indian country. So I want you to think broadly about that. But I also want to say this, don't forget the or. No one knows what this means, but I'm going to tell you what I think it means. And this is not, you're just going to take it as Kelly Stoner thinks it means this and nothing else. It says, okay, if it arises in Indian country, yes, full civil authority. But there's also full civil authority if something happened outside of Indian country, but the tribal code says the tribe can hear it. And you have to meet the Montana case for this one. You don't get that full automatic civil authority. Something happened outside of Indian country. I have a victim in front of me. I'm on the bench, the tribal bench. She is scared. She's in danger. My tribal code says that I can issue this order because she is a member of the tribe. I'm still going, if it's a non-member doing the battering, I'm going to have to meet the Montana test. Does that make sense to everybody? I'm going to tell you what that means. Okay, I see. Let me finish this thought and then I'm going to go back up to the chat. So let's go to the next slide. Okay, so or otherwise within the authority of the tribe. Something's happened outside of Indian country. Tribal code says, as a tribal judge, I can issue a protection order to my member who's there. So let's go on down, and this is what this test looks like. Tribal judges should be familiar with it. They probably are. I know that if I was ever in doubt about issuing a civil order, it matters, even if one party was a non-member, could have been a member of another tribe, but not Seminole, I would make sure that I put this language in my order. So all jurisdictions outside of Indian country, I'm telling you I'm a tribal judge, and I'm telling you I made a finding that Montana, if Montana applies, I have jurisdiction. Let's take a look at this quickly, this test. Here it is. I have to show that the member and the non-member entered into a consensual relationship with the tribe or its members through commercial dealing, contracts, leases, or other arrangements. I'm just going to say the case law on this particular prong, I'm always going to find that there's that relationship between the victim and the perpetrator because he has a relationship with her. But that's not my strongest argument. I'm going to put it in my order. But number two is my big gun here. It says the conduct threatens or has some direct effect on the political integrity, economic security, or the health or welfare of the tribe. If you look in your tribal code, you might find, not all have it, a purpose area for their domestic violence code. And it talks about how high the domestic violence is in the tribal community and how it's affecting the tribe. We have police involved, that costs the tribe. We sometimes have medical, that has to do with the economic security of the tribe. And it is dangerous. It is dangerous. And we have all these statistics to back that up. So I usually say I find both prongs are met, but number two, I'm going to list out what's in my code. If you want to see a really, in my mind, strong tribal code about the purpose and how domestic violence cases meet this Montana test, I would urge you to look at Tulalip. They have a purpose area there. It's the Potawatomis of Oklahoma also used to have a great purpose area. I haven't looked at their code in a while. If you don't get one of these prongs met, you don't have civil jurisdiction on matters arising outside of Indian country, but still within the authority of the tribe. So it gets a little more complex, judges, and I saw a couple of judges in our participant list. Gets complex if you're utilizing, there's nothing happened in Indian country, but your tribal code would allow you to issue a protection order. You're going to have to be sure and put this language in your findings about why you meet one or both of these prongs in your order. My thought process was always if I put it all in there, uh, my chances of getting this enforced for those folks who think tribes have no authority to issue civil orders over non-members, I say, first, I have the federal law if something arose in Indian country. Secondly, I have a tribal code and I'll meet one of these prongs. So I'm belts and suspenders trying to keep that order in force for the victim. All right, let me look. We can go to the next slide, but I'm losing track of my chat, Marlene.
Kelly, I'll go with
Yeah.
the first one. We had a
Oh,
question about back in the protection order, the child custody and visitation. It says, does that mean if a protection order is granted that the visitation stop, or will the order need to be specific to how the visitations will continue?
okay. If the order, the tribal protection order, grants custody to one party, and let's just assume we have our three full faith and credit pieces in our order, that custody order must be enforced everywhere. If it says no visitation is granted, and I always like to put in there, I'm finding at this particular time the perpetrator is a danger to the child. I like to beef it up. Let them know I'm seeing things in here. It's making me real nervous. And that's why I said no visitation. And that victim goes outside of Indian country and the perpetrator tries to get visitation or tries to visit the kids. That's a violation, may be treated civilly, but it still should be enforced as it's written. If the tribal judge is ordering particular visitation, best practice is, remember, these cases are about power and control. And judges, when you issue these orders, you're taking some of that control away. Things are going to get a little more dangerous. If you say, they're probably already dangerous though, and we know DV hurts kids in so many ways, sometimes lifelong. You're protecting those kids. You've heard testimony. You think visitation should only be by phone between these hours only. You make it as specific as you can. And typically what I see is a perp will do anything but call those 2 hours because it's about power and control. The perp thinks they're losing power and control. I know some jurisdictions also have these great, at a very low cost, these great supervised visitation over the phone so that the victim doesn't have to be involved. The perpetrator will call this particular number. There will be a supervisor listening in on the call, and usually they're transcribing what's said on the call too. So I would urge you to do a little research and see if you have that available for your in your jurisdiction. Okay.
There
I've
were a
already
couple other questions. Do you
Okay,
want me
yeah,
to go ahead and?
let's go ahead and get the questions and then I'll
Okay.
quickly.
So the next one, I'm not exactly sure what it's specifically about, but it says, does this mean they would not be allowed back on tribal lands and can be removed?
Okay, that probably had to go, I think it said exclusion, the federal statute by excluding the offender. That's what it says. I mean, banishment, exclusion, that's what it says. I do know that Alaska's struggling a little bit with that issue, I think now at this time. Um, boiling, I'm sure probably shouldn't do anything from memory, but I remember thinking that the state of Alaska was saying that violated their constitution of free movement within the state. So that'll be a legal argument back and forth. But this is the supreme law of the land, and it says tribes have that full civil authority. You may have to go to court to get there, but that's what it says. And so that's really all I can tell you about that. Yes, that's what it says.
Okay. And then we have another one that says, does it matter if there's a prior custody order in the state court affecting the children?
Oh, great question. Oh, Lordy. Well, there's this uniform law called the Uniform Child Custody Jurisdiction Enforcement Act. And it's got, you got to think about ICWA too. If it's an Indian child in state court, was ICWA followed correctly? I think I feel safe saying the UCCJEA, the Uniform Child Custody Jurisdiction Act, which applies to states, not tribes, will say the first custody order that had jurisdiction has exclusive continuing jurisdiction. You can't, as long as the parties are still in, one party still in the state. So that gets a little trickier for me. If it's an emergency and I'm the tribal judge sitting there and my code says I can issue emergency custody orders, I'm going to do that. But it may only be temporary until I'm going to do what my tribal code tells me, but it may end up into, and I've had this case myself, a battle between the tribal court and the state court, both issuing custody orders over the same child, but that uniform law says the first order issued, and guess who got the first one? I did in tribal court. The state didn't want to follow it, but when we went to state court to argue about it, the judge had to say, you've got it. So that one's a pretty complex question. I would always hope we're going to get a tribal court order early, but if there's an emergency, I think the tribal judges could do it. And hopefully there are people making safety plans. And then I think you're going to maybe have to send a lawyer over to state court. Or the UCCJEA also encourages tribal judge and state judge to get on the phone and talk to each other to try and work that out. Okay. Are there any more
Right.
questions?
There was one more that was asking about a third party. I'm not sure what specific
Yeah.
type that was tied
AB,
to.
do you want to come online or explain that question a little bit further and then we'll get to that? Okay. Or I don't know if you're talking about third party contact or, okay. A different person. Visitation can be by a different person, maybe supervising it. The judge can order that. I was talking about telephone visitation, and there are programs that for a very small fee will put one of their qualified supervisors on, so that I'm just trying to keep the victim from being re-traumatized, and that person will supervise the visit with the kids. Okay, I have about 15 minutes, so I'm going to have to speed up a little bit. So I'm giving you some tips here, mainly for judges. If you're doing the drafting, you're beefing this up. You're trying to make it bulletproof so that when it goes outside of Indian country, it's going to be enforced. It's not going to be penetrated. Okay, next slide. When we talk about jurisdiction over the persons or parties, I just want to make sure everybody understands that. When I'm on the bench, I want to show it's not a surprise to the defendant to be called into tribal court. There's a relationship with a member or someone who lives in Indian country or works in Indian country. Maybe they have a tribal child in common. Maybe they go to tribal events. Maybe the defendant works in Indian country also. I'm looking for those contacts to say, you've been here before. This should be no surprise to you. Or you have a relationship with one of our citizens, and this should not surprise you. Okay. Next slide. And this again is my tips for you. I'm trying to get across to tribal court judges how I would show this in the order, but I know in some places advocates draft those protection orders. And so you'll hear me from the bench asking the defendant, how long have you had a relationship with the petitioner? Do you have a child in common? Do you work here? Do you visit here? Do you have friends here? I'm asking the whole thing to try and demonstrate this defendant is not surprised to be here in Indian country. Okay, next slide. Reasonable notice and opportunity to be heard. Again, we're back to the full faith and credit pieces, and I'm trying to give you tips on how to demonstrate in the order. And so it means that you're giving defendant notice of a hearing and an opportunity to be heard. So that is imperative to activate the full faith and credit, as is jurisdiction of the parties and jurisdiction of the subject matter, which we've just received tips on. Questions maybe for the judge to ask, questions for the advocates to ask in advance, so you'll be ready to present the information to the judge. Next slide. And here are, where were you served with a copy of the petition? Were the timelines, the hearing dates, consistent with what the tribal court requires? And if the defendant comes in, you've got him. He's there. He must know something. And here's the thing, though, to my judges out there, you have to give the defendant an opportunity to be heard. I got a frantic call from one of the attorneys I supervise in Oklahoma, and she says the defendant came in and the victim's here, and the judge read the application for protection order and looked at the defendant and said, you better not open your mouth. I'm issuing this protection order right now. Yikes. The attorney's like, yay, we won. But also knowing this particular activation piece is not going to be there. That was an awkward position for the attorney to say, Your Honor, in order to activate the federal full faith and credit, the defendant has to be given an opportunity to be heard. I mean, you worry about irritating the judge, you worry about irritating your client, but it's got to be there. Next slide. All right. If we don't have any more, and if it comes to you, go ahead and put it in the chat. Any questions? I want to talk for the rest of my time about VAWA 2013 and 2022, what it means, and especially violation of a protection order. All right. Let's just keep going down because I'm going to be running out of time. So I'm going to go a little more quickly. Here are the findings. If you need findings to put in your tribal code, if you haven't been keeping statistics in your Indian country, what the DV looks like, I like to put this in here because this is what Congress found that led them to enact special domestic violence criminal jurisdiction in 2013 and special tribal criminal jurisdiction in VAWA 2022. You can see these statistics here. They may be worse in your Indian country. And you know who I would ask about that? Your tribal victim advocates. They probably are keeping track of at least the tribal victims coming through their organization, and they may be able to help you out if you want to put some of these statistics in. I think they're critical. Okay, next slide. I think what I saw is somewhere in the 90% range of physical violence against Native women is committed by non-Indians. That's why this becomes so important, because VAWA 2013 and 2022, this is the fact pattern. It's a non-Indian, because tribes already have criminal authority over all Indians. The non-Indian who commits one of these covered crimes in Indian country, sometimes it requires an Indian victim, sometimes it doesn't. But tribes that implement VAWA 2022 can exercise criminal jurisdiction over those non-Indians now. Before that, we had this 1978 case, Oliphant, from the Supreme Court of the United States that said tribes have no criminal authority over non-Indians. This was another congressional overruling of a Supreme Court case. And remember, Congress has plenary power over Indians. They have the authority to do this. So let's, and what we were seeing that led to all of this was tribes have no criminal authority. And even when we would refer as tribal prosecutors to the federal authorities, we had a super high declination rate for a variety of different reasons. That was not working. And remember, tribes have limited criminal sentencing authority. So we had to have something, and Congress stepped up and gave us what we know now as VAWA 2022. Next slide. All right, it's a reaffirmation, both of these statutes, of tribal inherent criminal authority over non-Indians committing certain crimes in Indian country. So let's go, I'm not gonna be able to go into detail, but you'll have the slide to the next slide. And remember this, to exercise this, there are certain due process requirements that are in the statute. Oh, here's where this was, Marlon. You will find all the requirements in the Indian Civil Rights Act. So if we do have that link, Marlon, we can drop it in for everybody's viewing pleasure. Okay, VAWA 2013 only had three crimes that these non-Indians could commit. They required an Indian victim. And so the tribes that implemented this, there were 5 of them in the beginning. They went to Congress and said, these are the things. They listed many things, many gaps. Here's what's happening to us. If we show up, a non-Indian has physically abused the kids, we can't prosecute that. That's not covered by 2013. Our law enforcement officers show up in a DV case, a non-Indian perpetrator, the officer gets assaulted, we can't do anything about that. And we cannot protect victims of sex trafficking, stalking, or sexual violence under VAWA 2013. So now let's get to the good stuff, because 2022, believe it or not, Congress listened. They heard. And what we get now, the next slide, please. Okay, let's go to the next slide. I want to get right here. This is what we get now. We had 3 in 2013. Look, we have domestic violence. We have dating violence. We have protection order violations. We have sexual violence. Do you see Congress listening? We have stalking. We have sex trafficking. We have child violence. We have obstruction of justice. And we have assaults against tribal justice personnel, which is very broad and may include victim advocates, behavioral health folks working with perpetrators who've committed a covered crime. These are the covered crimes. So now look at what tribes can do if they can meet the implementation requirements. They may have to do some code changing, but I will tell you also, everything but the last 2 crimes here requires an Indian victim. So we'll have a non-Indian perpetrating against an Indian in Indian country. They can prosecute that. Obstruction of justice and assaults against tribal justice personnel do not require an Indian victim. And this congressional piece also overrules another Supreme Court case, because usually in Indian country criminal jurisdiction, if we have a non-Indian offender with a non-Indian victim, it goes to state court automatically. The state has jurisdiction. No more. The state will still have that jurisdiction, but the tribes will have it too. Okay, next slide. Next slide. Get ahead of myself here. Okay, this is where I'm putting out some of the requirements that a tribe needs to meet to exercise this special tribal criminal jurisdiction over non-Indians. So let's go down to the next slide, because I wanted to talk about violation of protection order really quick. This is what it doesn't cover. And so you can look at that, except for you got to have an Indian victim, except for those 2 crimes I just mentioned, or if the crime took place outside of Indian country, these don't kick in. Next slide. Remember, it doesn't change any federal jurisdiction or state jurisdiction. This is solely tribal jurisdiction. Let's go down, if we can, to violation of protection order. I see I have about 3 minutes. Okay, here. Oh, my advocates out there, please listen to this. This is special tribal criminal jurisdiction over a non-Indian who violates a protection order in Indian country. It doesn't even have to be a tribal protection order. It's a valid protection order that meets full faith and credit requirements. Tribes can prosecute that now. And it has to occur in Indian country, but this is what I want you to take a really close look at is B, because it only covers these violations in a protection order. A violation that prohibits or provides protection against violent, threat, or threatening acts, or harassment against, sexual violence against, contact or communication with, or physical proximity to another person. It's only one of those pieces that can be prosecuted. Well, if he did, the perpetrator did all of them, but that's what you would show for a violation of a protection order. The protection order must have been issued against the defendant. In other words, they're the named restrained party. It has to be enforceable by the tribe. That tribal law would allow the tribe to prosecute or civilly enforce a violation protection order. And it has to meet those requirements I gave you at the very beginning. The protection order has to say the issuing court, in our case, maybe it was a tribal court, had jurisdiction over the matter, jurisdiction over the parties, and reasonable notice and opportunity to be heard. If it meets all of those requirements, that non-Indian can, and it has to be an Indian victim, the non-Indian can be prosecuted in Indian country for committing the violation. Next slide. Okay, we'll just skip on down. These are all the covered crimes. I wanted you to have them on the slides. And I want to say a word. I don't know that we have time to go through this now, but we have a newly refreshed tribalprotectionorder.org. And it's for tribes. It can be for tribal judges, victim advocates, for anyone who's curious about protection orders, what can be done, how to maybe do it more effectively. It talks about how to draft remedies clearly. It talks about civil enforcement. It talks about special tribal criminal jurisdiction. It just covers the gamut. And we refreshed it just a few months ago. There's also the National Center on Protection Orders, Full Faith and Credit. TLPI partners with them to put out checklists for tribal judges to use when issuing protection orders involving non-members, and protection order checklist that we worked with the National Center on Protection Orders and Full Faith and Credit to put those checklists out. So hopefully that, if you have additional questions, I'm very proud of tribalprotectionorder.org. I think I would use it definitely if I were on the bench again, where I were issuing protection orders. Next slide. Here's a checklist for you. Just if you want to print one slide off, just so you're going to be meeting activating the full faith and credit requirements of VAWA, that order be enforced everywhere as it's written. Remember, we also have to have this to prosecute the non-Indian for violating a protection order in Indian country. So that's just your one-stop shop there for those 3 elements. Next slide. And our thank you. I don't see any other questions, but if you have them, please put them in there. And who am I turning this over to?
Actually, we do have one question, and I'm going to just read it as is. It says, what would happen if there is an OSC involved? The OCS has a kid, so that's transposed a little bit, but it says is enrolled in 2 communities. For instance, the father or the mother enrolls the kids in one community and the grandparent enrolls them to another. What would we do if tribal court is dealing with this case? Would the kid need to be in the community where the parent enrolled them in, or would it be okay if the kid's in the community where the grandparent enrolled them?
Okay, I'm going to try. I'm thinking you're thinking about exercising jurisdiction, maybe over custody or something like that. I would say I'm going to look to my tribal code and see what it says to me. If it requires the child to be an enrolled member, or even if there is dual enrollment and we had parents, a biological parent enrolling in one and grandparents, and that's not an uncommon thing. Some tribes won't recognize dual enrollment. Some will say, if you were a member, you are a member, we can exercise jurisdiction. The other grandparents issue is the same. And so what we might end up with here are dueling courts, both trying to exercise jurisdiction over the same child. And I think it's an important one lesson I learned from the UCCJEA is getting on the phone, because judges sometimes can work these things out because they're not emotionally involved, and they might be able to craft a remedy that would be satisfactory to both. But me, when I'm on the bench, and Tiffany, I saw that nice note you wrote. Thank you so much. I remember you. I will say I am under an obligation and may have taken an oath that I will uphold the tribal constitution and the tribal code to the best of my abilities. And these are what these laws are what Seminole people have given me to work with. And so I'm going to be working with that, as is the grandparents' tribal judge, most likely. But if there's a way to, and I don't know if you have alternative resolution opportunities in either of the tribes you're talking about, where there's talking circles or some sort of something similar to that, where they could bring the families together and both judges would be there and they would try to work things out. I'm just tossing things out here because ultimately those children are going to go back and forth.
Thanks, Kelly. I think that's it. I'm not seeing any other questions coming up. But if you all do have any questions, you can always reach out to us. You can email us directly. Kelly's email is on the screen as well. So if you think of something later and have a question, we'll get back to you with the answers. So
Yes.
we just want to make sure you take a few minutes to fill out the evaluation. And I will go ahead and say thank you all for attending today's webinar, Strengthening Tribal Sovereignty, Enforcing Protection Orders under VAWA. And thank you again to Kelly Stoner, our Victim Advocacy Legal Specialist, for joining us today and presenting this information. The webinar recording will be posted on walkingoncommonground.org and will also be sent out to our mailing list. And I believe there was a link in the chat for that as well. And we will also send out the evaluation for anybody that wasn't able to do that while on the call today as well. But we do also want to let you know that this webinar is a part of a series of monthly webinar series to support the development and enhancement of tribal courts, tribal justice systems, and intergovernmental collaborations. The webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute, UND School of Law, who are our project partners. Our next webinar will be on Wednesday, September 10th, and it is titled Justice Reimagined, Healing Community and Improving Outcomes Through Joint Jurisdiction. And we should have a registration link in the chat for that as well. And again, thank you all for joining us, and we look forward to seeing you at our next webinar.